Taking a leave of absence is one of those things that most employees don't know much about. They aren't sure when they can take a leave and when they can return to work. They don't know about their job protection. So, today we are taking a few minutes to break down all aspects of the family medical leave law that would be important for anyone who needs to take a leave of absence. Hi, my name is Harlow Reed. I'm an HR leader and legal professional. And on this channel, we talk about employment laws, hot topics in the workplace, and share HR tips to help you manage workplace dilemmas with confidence. Now, today we're talking about Family Medical Leave Act, but I want to distinguish between that and some state and local jurisdictions who have laws that may be applicable to you that are more generous, meaning they could be paid time off or they could also give you more time than you receive under this federal law we are reviewing today. So let's talk about it. The information shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. And don't forget to like and subscribe. The Family Medical Leave Act, or FMLA, allows eligible employees, people who have worked for a certain period of time, to receive 12 weeks of unpaid time off during a 12-month period. Okay, so you get 12 weeks for every 12 months. Now, this 12 weeks can be taken all together at one time. Or it can be taken on an intermittent basis, which means that an employee could be working and on FMLA at the same time. Hours, let's say if you have a 6 hour shift, you work 3 hours and then 3 hours are considered FMLA. So you can take it on an intermittent basis. It doesn't have to be taken all at once. Okay, let's talk about eligibility. If you have worked for your employer for at least 12 months, and during that 12-month period of time, you have worked 1,250 hours, okay? Where this becomes a little confusing for people is those who leave their employer and come back. So if you leave your employer and then you return, there's a separation, either termination or resignation. It doesn't matter. You leave. Your employment ends. So, what could that look like? Well, let's say if you've been employed for 6 years, you give a resignation, work somewhere else, you decide you don't want to stay there and your position's still open. So then you reapply for your position that you had and you're rehired for your old position. All in all, let's say if you were only gone less than a year, eligible for FMLA, you have to work for 1 year and have 1,250 hours. So let's say if you're gone for less than a year and then you return and you're back at work in your old position for, let's say, 6 months, and you need to leave of absence. In order to determine your eligibility, your employer is going to look back over the last 12 months, which would include the time that you were not with your current employer. Okay. So, all of the time that you've worked for your current employer over the last 12 months would be considered. That is including the time before you were rehired. That time also has to be considered. So that would determine your eligibility for FMLA if you were to leave and then come back. Employers who have 50 or more employees within a 75-mile radius. So if you work for an employer with 10 employees, or 50 employees, but they are spread out in multiple states, it's not going to be applicable to them. So you're looking for employers who have at least 50 employees, and all of those employees are located within a 75-mile radius of one another. Okay, so you are now looking at applying for FMLA because you have identified your employer as someone who has to comply with this federal law. And you've also looked at the number of hours that you have worked over the last 12 months. And you know that you have worked at least 1,250 hours, including any time that you may have left the organization, if that applies to you. And now you are ready to apply for FMLA. Well, you have to make sure you have a qualifying reason: the birth of a child, your serious health condition, or a family member with a serious health condition as well. Health conditions are not just physical issues, okay? You can have a mental health issue. And in today's age, I think it's very important for us to be acutely aware of our mental state and the mental state of others. And if you experience issues that are serious and severe enough that require you to take time off, then I would encourage you to speak with your doctor and find out if, you need to do that. But take care of yourself, and FMLA is an option that you can use for mental health issues as well. So, how does it work? Well, first of all, you want to make sure that you give your employer at least 30-day notice so they can cover your area while you are out. If you can't give them 30-day notice, it's okay. The law says that when it's practical, you should. But if you have an emergency, you're not obligated to give that 30-day notice. You just notify your employer that you need to be out. Now, there is paperwork that you need to fill out. This is the documentation that is very important for you to complete and provide to your employer. This includes a medical certification that will be filled out by your doctor that identifies what your condition is that requires you to take a leave of absence. Now, this information is protected. It's your personal information, and it should not be disclosed or shared with others outside of HR, and it should be only be shared on a need to know basis. So just remember that you have protections under when you share your medical information as well. Do not work while you're on FMLA. If you get an approved leave of absence and your employer reaches out to you and says, I need you to do this or can you do that, that is called FMLA interference. That it doesn't mean your employer can't check up on you and say, how are you? How are things going? Is your expected return to work date still okay? And they have done that maybe once a month or something like that, that's reasonable. Or let's say if they have a quick question they want to ask you, and it happens once a month, that's okay. But if they're consistently asking you to fill out, answer emails, respond to questions, then that's no longer FMLA. That's an intermittent leave. One of the biggest benefits of FMLA is job protection. And that's why it's so important. I talked earlier about filling out your paperwork and having your documentation, because when you return from a leave of absence, that gives you the protection from retaliation. But also while you're on leave, your employer can't terminate you. They can't fill your job. They can't replace you. And they're also required to maintain your health insurance under the same terms you had before you went out on a leave of absence. Now, when we talk about retaliation, we are referring to coming back to work and seeing that your schedule has changed. It's inconsistent with what your schedule was before you left, or your pay is no longer the same, or you're no longer promoted to positions that you were eligible to be promoted to, or things that are affecting you in a negative way. Anything that is affecting you in a negative way upon your return from a FMLA leave is considered retaliation. It does depend on the circumstances, but for the most part, your employer is going to be aware that if you recently returned from leave, they don't want to make modifications to your job that could be perceived as retaliation. So, at the very least, if you start to experience those things, going to your HR department and inquiring about why. Now, let's talk about your return to work. Sometimes returning to work isn't as simple as coming back to the office after a 12-week leave. Your doctor, for example, if you're under a doctor's care, may want to evaluate your condition for an additional 2 weeks. And this is where the Americans with Disability Act would be applicable to you. I actually did a video on the Americans with Disability Act. I would encourage you to go back and watch that and see how that would be relevant to your circumstances if you need time that goes beyond the 12 weeks that is provided to you under FMLA. I want to take just a moment to clear up some common misconceptions about FMLA. One of the more common ones is that your employer can force you out of a job if you take a leave of absence. Retaliation is one of the most paid out claims under the law, under employment law. So, and it's one of the easiest things to receive payout for, because you have something called temporal proximity, where your employer takes an adverse action against you shortly after you've exercised a federal right.
and it's very difficult for them to explain why that was done. Most employers are going to be very familiar, especially those who have HR departments, and they're going to act accordingly and not retaliate against you when you return from FMLA. As a matter of fact, they're probably going to avoid doing anything with your job for at least a year. Another common misconception is that FMLA is paid leave. FMLA is not paid; it is unpaid. So you do when you're out for 12 weeks, you can use any paid time off that you receive through your employer to cover your pay if you choose to do that. You have to look at your policies that are at your employer, and that's one of the things I encourage people to do. Get out your handbook, read the policy. What does it say about leaves of absences that your employer may provide that are far above and beyond what is required under the FMLA law? Those are things that it's important to do so that you don't have a misconception about how you're going to be paid while you're out. Um, the other thing that I hear often is that it covers every illness. FMLA covers every illness, and that simply is not true. It has to be a serious health condition, a serious physical or mental health condition as defined by the law. And when you fill out your medical certification and your FMLA paperwork, your employer is going to analyze that to determine if you meet the eligibility requirements based on your health condition and the documents that you provided. Or misunderstood by many people is that your employer decides if you're eligible. Eligibility is based on the law. And that's everything you need to know about the Family Medical Leave Law. I hope you found this video helpful. Don't forget to like, subscribe, and hit the notification bell. If you have questions, drop them in the comments, send me an email. I'll do the best I can to answer. Thanks for watching, and I'll see you in the next video.